Counsel, you assert an injury on the part of the alliance of diverted time and resources. Isn't that just the cost of litigating, of pursuing this litigation?
I don't think so, Your Honor, for a couple of reasons. First, what respondent doctors have done here is chosen their particular practice as well as structured that medical practice to bring life into the world. When they are called from their labor and delivery floor down to the operating room to treat a woman suffering from abortion drug harm, that is diametrically opposed to why they entered the medical profession. It comes along with emotional harm. Dr. Scott talks about these being heartbreaking situations and some of the most stressful work she's had to deal with, Your Honor.
Well, I understand that, but I'm talking about the injury of having to divert resources to litigate this.
Oh, with respect to the organizational standing?
The alliance.
Absolutely, Your Honor. So we think Havens Realty is on all fours with this case. The best evidence of that, I believe, is the FDA's reply brief. The government resorts to the underlying briefs in the case to say that there was a contract and an economic harm. But this court's case specifically said that the fact that the nature of the harm was, quote, non-economic, did not prevent the court from finding an injury. In Havens, the court looked to two things: whether there was an impairment of the organization's mission, and second, whether there was an expenditure of resources. Both things are satisfied here. If you look at how our organizations have been harmed, they've been forced to divert resources from speaking and advocating for their pro-life mission generally to explaining the dangers of the harm from abortion drugs. One of the primary reasons that that's required is because in 2016, FDA took away the requirement that abortion providers report adverse events.
Well,
aside from
but that would be anyone who is aggressive or vigilant about bringing lawsuits, just simply by using resources to advocate their position in court. You say now causes an injury. That seems easy to manufacture.
So I don't think that's true in this case, Justice Thomas. I acknowledge that the lower courts have cabined Havens to say where you have sort of prelude to litigation types of activities. In those sorts of cases, those resource justifications don't count. In this case, if you look at respondents' declarations, they note that they have performed studies, they've analyzed studies. Several of those are in the record, and they're not short. They comb through Medicaid data, they comb through FAERS data to get at the true nature of adverse events. And all those sorts of things are neither a prelude to litigation, nor would they have occurred but for FDA's unlawful conduct in this case.